This is Bloomberg Law with June Grasso from Bloomberg Radio.
As President Donald Trump's agenda faces growing pushback from the federal courts, top administration officials are openly questioning the judiciary's authority to serve as a check on the president. After a Manhattan federal judge blocked Elon Musk's efficiency team from accessing Treasury Department information, Musk called for impeaching the judge. And Vice President J.D. Vance, a graduate of Yale Law School, wrote on X that judges aren't allowed to control the executive's legitimate power. Trump didn't back away from that.
But we're going to see what happens. We have a long way to go, and we're talking about fraud, waste, abuse. And when a president can't look for fraud and waste and abuse, we don't have a country anymore. So we're very disappointed with the judges that would make such a ruling. But we have a long way to go. We have to find all of the fraud that's going on. We have tremendous fraud, tremendous waste, and tremendous abuse, and theft, by the way. And the day you're not allowed to look for theft and fraud, etc., then we don't have much of a country. So no judge should frankly be allowed to make that kind of a decision. It's a disgrace.
Joining me is constitutional law professor David Super of Georgetown Law. J.D. Vance said judges aren't allowed to control the executive's legitimate power. Fair enough. But he's often argued that presidents can and should ignore court orders they say infringe on their rightful executive powers. Quoting Andrew Jackson, who said, "The Chief Justice has made his ruling, now let him enforce it." I mean, when the vice president and a Yale-educated lawyer says that, is it concerning?
It certainly is worrying, and presidents and other high officials who have been engaged in illegal conduct have been saying that for over 200 years, but it's no less disturbing when it happens. Of course, courts can't issue illegitimate orders, but the solution when they do that is to appeal them.
Trump has been stopped, at least temporarily, by about 9 judges. And the theory is, well, he's testing the limits so that this will go to the Supreme Court and expand his presidential authority. I mean, do you think it goes that far, or it's just he's doing what he wants?
Oh, I think it does go that far. There's a few of these issues that are arguably separate, such as the birthright citizenship, where he's violating not a statute but the Constitution itself. But for the most part, he's going out of his way to violate statutes that say how the federal government should operate. And in doing that, he's setting up a test case about whether any of these statutes bind him at all. Some of the things he's trying to do, there are legal ways to do it, and he hasn't tried to do it legally. He's deliberately violated the statute to set up a fight. What
are some of the things he's done, or one of the things he's done that he could have done legally?
He could have done a buyout under existing buyout authority. That requires an agency-specific examination of how many people they want to leave and in what positions. But he didn't bother to use that authority. He did something completely illegal with this mass email that's likely to cause us to lose precisely the federal workers we can't afford to lose.
So turning to Attorney General Pam Bondi, she issued 14 first-day directives. So a new memo warns the Justice Department attorneys against refusing to advance legal arguments they disagree with. Is this the way the Justice Department normally works? You know, you get an assignment and you argue the side that the Justice Department takes, or is this something different?
Well, lawyers are always required to act in the best interest of their client to the extent permitted by law and legal ethics. So it's not surprising that a lawyer might make an argument that if they were a judge, they would rule against. That's ordinary. But the implication here is that lawyers might be required to make arguments that they regard as frivolous. And that is generally not allowed in legal ethics. We expect lawyers to make good faith arguments to courts, not silly ones, and this could be read as requiring the latter.
The Justice Department is supposed to be independent from the White House. Is that always the case, though? Are there times when the Justice Department and the White House work closely together?
Well, the Justice Department is part of the executive branch, and it is supposed to serve the nation's interests under the general guidance of the president. But it's always been understood that because they're dealing with law and because the role of lawyers, particularly government lawyers, is very sensitive, that the Justice Department has to be free to honor the law and to honor its obligations to only make legitimate arguments in court.
And I think it's already been happening in some of these cases where judges see the Justice Department's arguments as just frivolous. For example, in the cases over, you mentioned birthright citizenship, where it seems to be pretty clear-cut that Trump can't do that. So does the Justice Department risk losing credibility with the judiciary?
Yes, and I think that's already started to happen. Some of the arguments that have been put forward, not just in the birthright citizenship case, but in the funding freeze cases, have been very strange, and the judges have commented on them. A judge in one of the funding freeze cases said that the government lawyers were claiming that the executive agencies must follow the president's priorities. He says, no, executive agencies must follow the law, because even the president is constitutionally required to take care that the laws be faithfully executed.
In one of the memos on the first day, Bondi created a weaponization working group, which strikes me as an ironic name, to say the least. And she's targeting for investigation there Special Counsel Jack Smith, New York AG Letitia James, Manhattan District Attorney Alvin Bragg, Justice Department personnel who worked on January 6th, etc., accusing them of improper investigative tactics and unethical behavior. Going after an elected DA in Manhattan, is that really the Justice Department's purview?
In principle, there can be violations taken by district attorneys. Some of the actions in the civil rights era were against people using government powers to perpetuate illegal racist subjugations. So the fact that someone is a state attorney general or a district attorney doesn't make them waterproof. But in this case, the strong implication is that this is payback for prosecuting or investigating her boss, President Trump. And if the Justice Department is seen as making decisions based on the personal interests of officials, Mr. Bragg not only prosecuted Mr. Trump, but persuaded a jury of his peers to convict on all counts, then the Justice Department becomes a political tool and will have very little respect.
We've talked about this with reference to Supreme Court justices, but at her confirmation hearing, she said there will never be an enemies list within the Department of Justice. Here's Rhode Island Senator Sheldon Whitehouse, a Democrat, questioning her.
And I'm questioning you right now about whether you will enforce an enemies list that he announced publicly on television.
Oh, Senator, I'm sorry. There will never be an enemies list within the Department of Justice.
And here she's on day one, she's targeting the people who are and have been on Trump's enemies list. So I wonder, what is the point of those confirmation hearings?
Well, the point is what you've just demonstrated, to have them acknowledge the illegitimacy of this action. There's nothing that Congress can do in a hearing to stop someone who's determined to violate the law to do so, but they can have them acknowledge up front that what they're contemplating doing is improper.
I think it's a couple of dozen prosecutors who worked on January 6th cases have already been fired. Is there any recourse for them if they think that their firing was based on the position that they took, the assignment they were given?
Certainly. There's a strong principle of due process that the Supreme Court has articulated many times, that one must be told what the law is and given a chance to conform one's behavior. Applying law retroactively is inherently improper. These were people who were given assignments by their lawfully designated bosses to conduct investigations, and they're now being criticized for doing something that was perfectly legal when they did it. that kind of retroactivity is obviously a due process violation. It may be a violation of federal laws designed to keep government employment from being used for patronage purposes.
President Trump has outright said he's going to fire the FBI agents who were involved. So I guess they have some evidence there of his intent. So the Department of Justice has signaled that it's going to use criminal investigations to root out DEI practices in the private sector. That's according to one of the executive orders that Trump issued, and then the DOJ memo calls for specific steps to take within weeks. I don't even know what to say about that. I mean, criminal investigations for DEI policies?
Well, it's quite remarkable. I can see why they keep using the initials, because that's saying we're criminally investigating you for inclusion. We're criminally investigating you for equity. Inclusion and equity tend to be the things that the law supports. So they're using DEI as a cartoon villain rather than looking at what's actually involved. DEI programs are enormously varied, and it's hard to imagine many of them engaging in any criminal activity any more than any other program could do that. The notion that they're going to bring these cases suggests that they're contemplating using the law for harassment.
Whenever you're charged or a complaint is filed against you, it's a hassle, it's expensive, etc. But does this seem like something that a judge would dismiss, on a summary judgment motion or even before?
Judges generally like to give the prosecution a chance to be heard, but in a situation like this, when there's so much evidence that the criminal law will be misused, the president and other senior officials essentially admitting that, I think judges may feel that the fairest thing to do is dismiss these cases immediately and not force people who are following legitimate orders to go through this sort of burden.
Coming up next on the Bloomberg Law Show, more on those Bondi memos and the attack on sanctuary cities. I'm June Grasso, and you're listening to Bloomberg. New Attorney General Pam Bondi has unveiled a series of directives designed to overhaul a Justice Department President Trump claims is biased against conservatives. The directives roll back Biden administration policies and align the Justice Department with the priorities of a White House determined to exert control over federal law enforcement and purge agencies of career employees it views as disloyal. I've been talking to Georgetown law professor David Super. Bondi has also ordered the defunding of jurisdictions that refuse to cooperate with federal immigration authorities. So the defunding of sanctuary cities and states. That was tried before with Jeff Sessions, right?
Well, that's very remarkable irony that they would think about doing this, because conservative justices on the Supreme Court held that the federal government has no right to dragoon state and local governments into carrying out its policies. That's a fundamental tenet of federalism, and Mr. Trump and other conservatives have championed federalism, and this is suggesting that state and local governments are just sidekicks of the federal government. That's not constitutional.
She's reinstating the death penalty. That's been done before. There's nothing illegal about that, right?
No.
So she's also calling for an October 7th task force seeking justice for victims of the attack and addressing the ongoing threat posed by Hamas and its affiliates. Is that in the purview of the Attorney General? It sounds like it's foreign affairs.
It sounds like foreign affairs to me. On some matters, there can be cooperation between justice and state, justice and defense, justice and CIA. So it's certainly conceivable that there could be something to investigate there. I'm not privy to what intelligence they might have. If they don't have more than is publicly known, I'd be worried about a fishing trip, but maybe they do have more.
What they're doing is they're reassigning attorneys within the Justice Department to immigration. So, for example, they're reassigning environmental lawyers and antitrust lawyers to the Sanctuary Cities Working Group. Will pulling resources from other areas and concentrating on immigration come at the expense of the department's other priorities like terrorism and white-collar crime?
Oh, certainly. And lawyers develop specialties, develop expertise. In my areas of expertise, I like to think I'm a good lawyer, but I can name you 20 areas where I would be completely incompetent. I don't practice in those areas. That's true of any lawyer. So this is a good way of wasting valuable resources and letting important laws go ignored while pursuing cases that likely have no merit based on what we are publicly aware of.
Of the things that she's planning, or at least she's written memos about, is there one area that you think that is most concerning?
Well, it's the theme. The theme is politicizing the Justice Department to pursue a particular political agenda. Once we do that, then the Justice Department is going to lose something permanently. Whoever the next president is will not have a Justice Department that is trusted by the courts the way it traditionally has been.
Some of these orders that he's handed down, let's use birthright citizenship because that's so obviously a problem, illegal, whatever. Is he getting legal advice on these from the White House counsel's office or Justice Department? It seems like they're so disconnected, some of them, from basic legal concepts.
I think these are written by the people behind Project 2025. And those people have an extremely ambitious, radical agenda of overturning the separation of powers and the system of checks and balances that has guided this country since its founding. That's the legal advice that is behind all of this. The rest of what they're doing is hard to take seriously. You read references to cases in their memos, you go look up at the case, and it says the opposite. So I don't think this is a serious effort to think about what the law is. This is a radical effort to change what the law is.
Do you think that the Supreme Court will be receptive to Trump's efforts?
I don't. The implication of this is that he's not governed by the law and that the courts have no power over him. That turns Supreme Court justice into a very modest, relatively insignificant figure, and I don't think that these justices are willing to give up their constitutional role and become figureheads. I think they want to decide cases based on the law, and President Trump's theories here are so radical that they would greatly limit the rule of law in this country.
Thank you so much, David. I always enjoy our conversations. That's Professor David Super of Georgetown Law. Turning now to immigration. The Justice Department is suing the state of Illinois and the city of Chicago over their sanctuary city policies. The lawsuit accuses them of obstructing the enforcement of immigration laws as ICE and federal agents are ramping up their search for undocumented immigrants to be deported. Here's Border Czar Tom Homan.
I would love to arrest a bad guy in a city or county jail. But in sanctuary cities, we don't have access. So they're going to release a public safety threat back into the community, which I think is foolish. Puts the community at risk, puts our officers at risk, and puts the alien at risk.
But Lee Gallant, the deputy director of the Immigrant Rights Project for the American Civil Liberties Union, says only federal authorities can enforce these raids.
I think the states will have very, very strong arguments that they don't need to cooperate. They can't obstruct, but they don't need to cooperate.
Joining me is Elora Mukherjee, a professor at Columbia Law School and director of the school's Immigrants' Rights Clinic. Elora, will you start by explaining what a sanctuary city or state is?
A sanctuary city or a sanctuary state isn't defined in the law in any way. It just means that a jurisdiction may have some policies that restrict a degree of cooperation between local law enforcement officers and the federal government, ICE. There is a broad range of policies that different sanctuary jurisdictions have, so it's not a uniform term.
Attorney General Pam Bondi directed the Justice Department to identify local governments with policies that impede immigration enforcement and to take action where appropriate. The first lawsuit filed by the Justice Department is against Illinois and Chicago and elected officials there, including the governor and mayor. Tell us what the administration's allegations are.
The Trump administration is alleging violations of the Supremacy Clause. They're saying that local Chicago laws, a Cook County ordinance, and an Illinois state law preempt federal law. The Trump administration also alleges unlawful discrimination against the federal government and the unlawful regulation of the federal government in violation of the Supremacy Clause. The Trump Department of Justice is seeking declarations from a federal district court in Chicago that the state laws and the county and city ordinances violate the Supremacy Clause and are therefore invalid.
So this state law was first passed in 2017. Have there been attacks on it before?
In the first Trump administration, the Trump administration signed an executive order that is virtually identical to the one that is currently at issue now that the president signed in his first days in office. And in the first Trump administration, multiple federal courts deemed that the executive order from that time was unconstitutionally broad, unconstitutionally coercive against local jurisdictions, and that was enjoined, meaning blocked by the federal courts from taking effect.
Does it seem likely that the same thing will happen with this, or have they added anything to their lawsuit, to their argument?
I anticipate that the Trump Department of Justice will not be successful in their litigation in Chicago. It's also worth noting that on February 7th, San Francisco, Santa Clara, King County in Washington, Portland, and New Haven also filed a lawsuit in the Northern District of California, a federal district court there, alleging that the sanctuary jurisdiction executive order, which would block sanctuary jurisdictions from receiving billions of dollars in federal funding, is illegal and unconstitutional. These localities argue that the president's executive order violates the 10th Amendment, violates separation of powers and the spending clause of the Constitution. These localities further argue that Trump's new executive orders violates the Due Process Clause of the U.S. Constitution and a statute called the Administrative Procedures Act. I anticipate that these localities will be successful in blocking that executive order.
On his first day in office, President Donald Trump signed an executive order calling for federal funds to be cut off for any local government with sanctuary policies. And Attorney General Pam Bondi issued a memo calling for the Justice Department to start enforcing the order. Elora, tell us about that memo.
That memo is in tandem with the executive order, and these localities have sued to stop that executive order and that February 5th Department of Justice memo from going into effect. It's notable that the February 5th Department of Justice memo threatens the termination of funding to local jurisdictions and threatens both civil and criminal prosecution for law enforcement officers and other officials in these sanctuary jurisdictions.
Depends on the city, but are we talking hundreds of millions or billions of dollars in federal aid to these cities?
Collectively, billions of dollars in federal aid to these cities.
So they've also, in Trump's executive order, vowed to go after local law enforcement officials who don't cooperate with federal immigration enforcement. Did they do that in the last administration?
This threat to pursue both civil and criminal prosecution of local law enforcement agents and local officials who do not cooperate with the federal government on immigration enforcement is new. It is also unconstitutional. It clearly violates the 10th Amendment and violates a long-standing principle of constitutional law, which is called anti-commandeering. The federal government cannot commandeer, cannot force localities and states to carry out federal priorities.
There was a memo allowing ICE to go into sensitive locations like churches and schools and hospitals. Has ICE done that?
ICE has rescinded the sensitive locations memo, which previously stopped ICE from carrying out immigration enforcement in locations such as schools, hospitals, places of worship, and public demonstrations. As far as we know at this time, there have been no immigration enforcement operations in schools nationwide. And in the first Trump administration, there was very limited immigration enforcement taking place in the medical care context. We haven't heard of widespread ICE enforcement in the immigration context or in houses of worship in this administration.
New York City, because of possible ICE raids at schools, some immigrant families are keeping their kids at home. And the school's chancellor came out and said that the policy at city public schools hasn't changed and basically that a warrant is needed. Quote, "We unequivocally stand with all children in our city regardless of immigration status." But it seems like there's fear no matter what the government says.
The Trump administration has created a pervasive sense of fear among immigrant communities nationwide. It is not surprising that after the rescission of the sensitive locations memo, the number of children attending our public schools has gone down. And it's important to reiterate that there have been, to date, no immigration enforcement actions carried out in public schools, and families should continue to send their children to school.
There's a dispute in New York City about New York City sanctuary status because of the actions of the mayor, Eric Adams. He wrote a memo to general counsels for all agencies, directing employees to ask officers, ICE officers, for their name and badge number, a warrant or subpoena, and call their agency's counsel. Quote, "But if you reasonably feel threatened or feel for your safety, you should give the officer the information they've asked for or let them enter the site." And critics say that's a violation of New York sanctuary law.
Yes, the wording of that memo is problematic, and it has left city officials without clear guidance on how to proceed.
About the ICE raids, how are they proceeding? Some of them have been highly publicized. The one in New York where they arrested just 100, I think, people was highly publicized because the new Secretary of Homeland Security went on the raid. How are they carrying them out across the country? Is it by the book?
It is unclear how these ICE raids are being carried out. In the first weeks of the Trump administration, ICE was releasing data on how many individuals were being arrested in ICE raids. It appears that about half of those individuals who were arrested did not have criminal convictions and were so-called collateral damage in the arrests. Now it seems that ICE is not releasing data on how many arrests they are carrying out nationwide, so it is hard to know who is being arrested and whether or not those individuals actually pose a danger to public safety, as the administration claims.
On Sunday, a judge issued a temporary restraining order against 3 Venezuelans being sent to Guantanamo. Do you think that sending migrants to Guantanamo is going to be upheld by the courts?
There are serious legal questions about whether the Trump administration has the authority to send individuals to Guantanamo Bay. What is clear is that the Trump administration is trying to instill fear in immigrant communities nationwide and let people know that the United States of America is no longer a safe haven for immigrants, for migrants, for asylum seekers, and others, and that message is being broadcast around the world.
And what is the situation right now at the southern border?
So the Trump administration has issued executive orders that purport to close the southern border completely to asylum seekers and other migrants by declaring that there is an invasion at the border, although if you look at the data, crossings are at a 4-year low, so the data doesn't support that there is an invasion. And earlier this month, a number of immigrants' rights organizations filed a lawsuit challenging the constitutionality and the legality of those executive orders, saying that the president, with a stroke of a pen, can't supersede laws passed by Congress which guarantee a right for people to seek asylum regardless of how they enter the United States. So that case is pending.
Thanks so much for joining me today, Elora. That's Elora Mukherjee, a professor at Columbia Law School and director of the school's Immigrant Rights Clinic. In other legal news today, a federal judge in Boston temporarily blocked enforcement of a federal employee buyout offer by President Trump's Department of Government Efficiency. Federal Judge George O'Toole Jr. says the order will remain in effect until he issues a ruling. Attorney Elena Goldstein with the Democracy Forward Foundation argued for the plaintiffs in the case.
We are pleased that today the court continued his injunction from last week, continuing to enjoin OPM and defendants from implementing the fork-in-the-road directive, the so-called buyout.
The deferred resignation program has been spearheaded by Elon Musk, who's serving as Trump's top advisor for reducing federal spending. Under the plan, employees can stop working and get paid until September 30th. Democrats and union leaders have said workers shouldn't accept the deferred resignation program because it wasn't authorized by Congress, raising the risk that they won't get paid. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.